Thank you for joining our webinar on Justice Adapting the Manitoba Courts. Some housekeeping notes. If you experience technical difficulty at any point, please exit the meeting and return using the link provided. Note that this session is being recorded and LexisNexis will distribute the link in a timely manner. On behalf of LexisNexis and the judges participating on the panel, we hope you are all staying safe during these unsettling times, and thank you for doing your part to flatten the curve. As COVID-19 events continue to unfold, LexisNexis Canada is working to support the legal community. The Practice Advisor Coronavirus Resource page provides a document kit that can be downloaded for free. Please visit lexisnexis.ca/COVID-19 for more information. Today's webinar will now begin. I would like to introduce the moderator, Timon Sisik from LexisNexis Canada. Timon, over to you.
Hello and welcome everyone to the LexisNexis COVID-19 Justice Adapting webinar series. I'm Timon Sisik and I will be the moderator for today's panel discussion. The webinar is part of a series of discussions LexisNexis is presenting across Canada to bring the legal community together in sharing updates and information about how lawyers, the law societies, and the courts are adapting to the pandemic. Today, we are fortunate enough to have with us on our panel the chief judges and justices from 3 different Manitoba courts to share their experiences and insights. Joining us today are the Honorable Chief Judge Margaret Wiebe of the Provincial Court, the Honorable Chief Justice Glenn Joyal, the Court of the Queen's Bench, the Honorable Chief Justice Richard Chartier of the Court of Appeal. I believe everyone listening already recognizes generally the unprecedented impact this pandemic has had on our justice system, so I won't dwell on that. We also recognize that the situation is rapidly changing daily and that the information we have is in flux. However, we believe that open lines of communications within our community are key to ensuring the justice system and its participants remain resilient and adaptive to the challenges ahead. As such, we greatly appreciate the panelists for taking the time to join us today. The format of our panel discussion will take the form of questions that I will ask to the panel and then invite each panelist to weigh in on that issue. Some of the questions will be generally applicable across courts, whereas others will only be related to one court in Manitoba. This webinar is accredited for 1 substantive hour of CPD credit, and because we only have 1 hour, I would like to take advantage of the time and keep this introduction brief. So with that, I will start with our first question. As a matter of introduction, can each of the judges on the panel please provide a brief overview of the major changes each of your courts have implemented? I understand that there are rather lengthy notices to the profession that most of our viewers are familiar with, so I won't ask you to repeat those. But could you simply give a brief 1-minute summary each from your courts as to what some important news should be highlighted before we explore the more specific questions? I'll start my question here with Chief Justice Chartier, then move to Chief Justice Joyal, and finally Chief Judge Wiebe. Chief Justice Chartier.
Yes, good morning, Mr. Sisik. First of all, bienvenue à tous et Tansi. We're happy to be here and answer all the questions that have been submitted. Nous ne sommes pas en temps normal et donc les mesures que nous avons mises en place sont très différentes de cour en cour ou de province en province. As we indicated, we're going to continue our institutional obligations and as well balance the public health concerns that we're all facing. Our first phase was to go and like all Winnipeggers and all Manitobans to flatten the curve and transition towards now a higher level of normalcy. This doesn't mean that it's business as usual in the courthouse. Au contraire, social distancing measures are in place and the public's still not allowed to enter the courthouses. As of April 20th for the Manitoba Court of Appeal, all of our appeals are now being heard remotely by video conferencing for appeals. And for motions and applications, they will be done and they are being done by teleconferencing. So there's my minute.
Thank you very much, Chief Justice Joyal.
Thanks very much, and let me welcome everybody as well. I think Chief Justice Adapting gave a good sort of contextual background with respect to how we got here and some of the difficult and limiting decisions that have to be taken early on. So I'll not repeat those. I'll simply sort of underscore the most recent news from the Court of Queen's Bench, and it applies in the areas of civil, criminal, family, and child protection matters. So as of May 25th, with the exception of jury trials, all scheduled viva voce in-person trials will be proceeding. In addition to that, any and all scheduled pre-trials, case management meetings, case conference meetings, mediations, and any and all other miscellaneous lists, important lists, my characterization of them as miscellaneous minimizes importance, things like the child protection intake list, triage list and family matters, all of those will be ongoing as well, but they will be done remotely. All of that to say that by May 25th, the Court of Queen's Bench, with the exception of jury trials, will be operating at 100% capacity. So we can get into some of the reasons why and what nuances might attach to that as we proceed. But as of May 25th, the court will be offering effectively all of the services that previously offered, with the exception of jury trials, which are set to recommence in September of 2020.
Thank you, Chief Justice Sherrill and Chief Judge Wiebe.
Thank you very much, and welcome to everybody as well. For those who are not fundamentally knowledgeable about the provincial court, I'll just give you a quick background and say that we do about 98% criminal work, and then we do a bit of child protection work and family work outside the city of Winnipeg. Since the pandemic started, we have continued to sit in court on in-custody matters. So we have continued to hear in-custody bails, sentencings, trials, and some preliminary hearings, as well as continued our drug treatment court and our mental health court remotely. What is going to change what has changed as of May 1st is we have now started to run our child protection dockets remotely. Those were matters that we had not been able to get to before. And we are also, as of June 1st, going to be opening up so that we can hear out of custody matters. We're going to have some challenges with that, which we will talk about. But what's changed in the courthouse is the manner in which we're conducting the hearings. So most of the hearings that we conduct now will have a judge and a clerk present in the courtroom. Occasionally we'll have counsel attend to the courthouse, but more often counsel is attending remotely, either by teleconference or by video. And that is the way the majority of our hearings are being conducted. That's not the case for trials or preliminary hearings. People can still be transported to court so that we can deal with them in that way. So going forward, our major centers will be hearing out of custody matters, which have been suspended until June the 1st.
Okay, thank you very much. This is our second question here, and it's for Chief Justice Chartier. Has COVID-19 affected trial court processes differently than the appeal courts? I assume it has, and how so?
Well, Mr. Cizik, let me start off by saying, thank goodness I am not a trial court chief. I see what my colleagues in the trial courts are having to do when the COVID-19 pandemic fell upon us. Like for trial courts, in-person hearings became very problematic. But unlike trial courts, appeal courts, we typically don't hear testimony, we only hear argument. So we don't hear from witnesses. We don't have to assess credibility or weigh evidence. There's no requirement that our hearings be recorded and transcribed for appeal purposes. What really matters at the appeal level is, I guess putting it another way, the physical presence of the participants is not as important at the appeal level compared to trial courts. So what we're interested in is the content of their legal arguments. That's what we seek, not their physical presence. So what matters like all hearings, is that they get a fair hearing. So for us, a solution became apparent when we transitioned to a higher level of normalcy. During the pandemic, video conferencing became a viable option to in-person hearings. That's what we've been doing. We announced it on April the 3rd. And for us, it's been business as usual, except that it's done by way of video conferencing. So all of our appeals have been proceeding by video conferencing.
Okay, thank you. This question goes back to Chief Judge Wiebe. How are the courts dealing with matters arising in remote communities, particularly many of the First Nations communities where they have been and remain closed during the pandemic?
Thank you. So as your question indicates, many of our First Nations communities have been closed during the pandemic. The Manitoba Court sits in over 50 communities across the province, and many of them are remote Indigenous communities. So all of those hearings were suspended during the pandemic. So our major challenge with respect to the remote communities, many of which we actually fly into or we boat into, is to determine how we can resume the court hearings in those communities. So we've been reaching out to the Indigenous leaders in the various communities. We've spoken to some. We have a number of meetings set up to determine when they may open their communities and invite people back in, first of all, to figure out when we can resume those court hearings. But in the meantime, we have to do an assessment of all of the facilities that are in each of those communities, because we sit in community halls, we sit in band halls, many of which are smaller centers. We're going to have to figure out how we're going to be able to comply with social distancing protocols, with sanitization of the facility. We often have as many as, you can have 200 people show up to a facility for a hearing. And so we have to anticipate how we're going to manage dealing with those very, very large dockets. So a lot of that is very challenging for us to figure out, and it's a very big undertaking. We're also considering in which communities we may be able to do more remotely. The challenge there is, particularly in the north, and many of the Indigenous communities, they do not have access to internet. They don't have the bandwidth to introduce it. And so we're working very hard to figure out how we're going to get back in. But we want to get back in because we need to bring, equal and meaningful justice to those communities as well as all the other communities.
It's great to hear that remote communities aren't being overlooked. So happy to hear that. This question is for Chief Justice Joel. In your notice of May 4th, 2020, you noted that by May 26, 2020, assuming that there are no sudden developments in the still fluid COVID-19 situation, with the exception of jury trials, the Court of the Queen's Bench will be operating at 100% capacity in its various areas of criminal, civil, family, and child protection services. As Chief Justice of Manitoba Superior Trial Court, can you identify the single most important factor that has enabled the resumption of service so quickly?
Well, I think there's a few factors. I don't want to privilege one over the other. Let's begin with sort of a contextual factor. Chief Justice Shapsey has a fetish for statistics, so I don't want to the situation as it relates to Manitoba, but I think it'll be quite illuminating to hear from him. But the long and the short of it is Manitoba, comparatively speaking, across the country, is in a much more privileged position. So let's begin with the obvious, which is to say we're not Ontario, we're not facing the same gravity that some of our eastern neighbors or even our western neighbors are. That's the first thing. But then allow me maybe to be a bit institutionally self-congratulatory, because I think there are unique things that we've done that have assisted us. They're peculiar, again, to our level of court, and not every court could do it. Beginning with the fact that we, over the last 10 years, in the areas of criminal, civil, child protection, and family law, have introduced certainly transformative models that relate to scheduling and case form. Those practitioners out there in those areas of expertise will know what I'm talking about. Some like them, some don't, but there's no denying institutionally from an administrative point of view that those models have left us in a very advantageous position to be able to pivot at a time like this. And nobody anticipated this type of crisis, this type of pandemic. But fortunately, those models in each of those areas, as it relates to scheduling and case flow, have allowed us a certain suppleness. The next factor, I think, is the decision that we've made not to adjourn any of those matters sine die to an uncertain or infinite future. And that's allowed us to maintain control of all of those adjourned matters or potentially adjourned matters in the areas of child protection, civil, family, and criminal. And we've basically now rescheduled all matters, or we will be rescheduling matters. We address them by way of resolution conferences, JDRs, and the like. So we have accounted for everything. Nothing is put off into an unknown future. While there may be small delays, everything has been accounted for. The next factor, I think, is our use of technology. While we don't pretend to be on the cutting edge of everything, to the extent that we've been able to, and we have been able to, use video conferencing and teleconferencing, there's a whole area of our judicial service that is now up and running because of our use in that area. And then the final 2 points, which I don't want to de-emphasize as well, is the extraordinary collaboration and I think cooperation that we've received are. We've profited in every area that I've talked about: child protection, family, civil, criminal, with interaction with the bar, where they've given us, I think, their best advice, their best wishes, as it were, and their list of wants. And we've tried to incorporate that, and that's worked in a kind of a symbiotic way. Then finally, but certainly not least, the incredible pluck and willingness on the part of my colleagues in the judiciary and the Court of Queen's bench to step up and do whatever it is that we've asked them to do. So all of those things, I think, have led to what is a pretty extraordinary situation in our court anyway, to be back up and running at that level of capacity. And, hopefully there are no unforeseen developments and we can move forward.
Mr. Cisyk, can I jump in on that? Chief Justice Royal indicated, the different realities with, let's say, Ontario, our neighboring province, and our province. And as he indicated, we in our province, the government lifted restrictions on Monday. Here we are Friday. And everybody, of course, is following the statistics very closely. There's only been 4 new cases of COVID-19 over that 4-day period, but still, it's new, so we're going to be measuring all of this. But we have a population of approximately 1.4 million people. And since the beginning of the pandemic, there have been 283 cases reported. And as of yesterday, we have 5 people that are hospitalized. 5 people in all of our province. None, 0, are in intensive care. And there are only 33 active COVID cases in the entire province. When you compare that with Ontario, you see that in Ontario, over the same period of time where we've had 4 cases, Ontario has had 1,603, so 400 times more than us. But because Ontario is 10 times larger in terms of population, the proportion is reduced from 400 to 40, but it's still, in Ontario, there are 40 times more cases per capita in Ontario than there is in Manitoba. And that's why we're able to move more quickly than Ontario. It's simply because we are in different realities. But I want to stress the importance, like Chief Judge Wiebe has indicated and Chief Justice Royal has indicated, it is not business as usual. The social distancing measures are in place. There's fogging that's being done. There are plexiglass dividers that are being done. We have to measure. We've looked at this and we said, well, there's a difference between danger and risk. And if there's danger, of course, we're not going to open up. But now I don't think we can talk realistically about any danger anymore. It's more about managing the risk based on our numbers. And because it's not business as usual, we can move towards a level of normalcy because we can do the social distancing. And so far, so good. But as soon as the numbers go up, if they do go up, then all 3 courts, we're going to reevaluate. But for the time being, so far, so good.
Okay, thank you. That definitely answers my my next question about the comparison between the different provinces as well. Moving away a little bit from the procedural aspect, related question, Ontario, Alberta, British Columbia, and Quebec have suspended their substantive limitations periods and their procedural limitations period. This is a question for each of the panelists. Would you be happy to see some suspension or relaxation of limitations at this time by the legislature, or do you not think that it would be a wise idea? And I'll start with Chief Judge Wiebe.
I think it's probably a question that's more applicable to the other courts with respect to the limitation periods. I mean, we can speak to practice for filing motions and that sort of thing, which obviously I think all judges are going to give dispensation to timelines given the current situation. But in this case, I think Chief Justice Joyal, with all the civil claims, maybe, or Chief Justice Chartier may speak more properly to that one.
Okay. Chief Justice Joyal?
Yeah, I'm not in favor of that move. I certainly don't question those provinces that applied for that approach. Of course, those are approaches that were mandated and sponsored by governmental orders and council. We didn't have to do that. So I guess my answer would be rooted in both a practical and principled response. The practical response is our registry has not rejected any documents and has ensured that all documents are received. To the extent that there's been confusion from time to time, that's always been rectified. So we accept all documents, and there's no reason why documents can't be filed. And the situation in Manitoba is such that there's no reason those documents, can't be filed as they otherwise might have to be. The bar, I think, has collaborated with us when we requested that they refrain from filing non-essential documents in the early going so as to not overwhelm registry. They, again, accepted our request, and I think they were very streamlined. So the issue, practically speaking, has not come up. But let me just end by invoking maybe the principal reason why I'm not in favor. I think there's an important policy reason behind limitation periods, and I think we ought not to lose sight of that. And it should be extraordinary when limitation dates are suspended or set aside. Don't forget, for every statement of claim, for every action, there's a party on the other side who probably wants to know that there is an end, there's a closure. And the longer you suspend a limitation date, the longer you potentially prolong a party's level of uncertainty. Even if we were in a different situation, frankly, I would have preferred an approach different than suspending limitation dates. I would have preferred some attempt to perhaps file a subsequent affidavit explaining why on a particular given day a filing couldn't take place, rather than just willy-nilly and comprehensively suspend the limitation date. That's a pretty radical move, and I think it's reserved for provinces who were much harder hit than ours.
Thank you.
Mr. Cizik, at the Court of Appeal, we, like the Court of Queen's Bench, have not suspended or relaxed our limitation periods for essentially the same reasons Chief Justice Royal has indicated. We did send out a joint notice to profession, Court of Queen's Bench and Court of Appeal, with respect to our registries, indicating that. But in our notice, we also indicated that we have asked the judges of our respective courts to exercise their discretion, mindful of the special circumstances that are arising because of the COVID situation when considering any extension of time requests or special accommodation requests. We also, and this was in cooperation with the Law Society of Manitoba, both registries announced, I think, Chief Justice Royal, I think it was March 18th as well, that we will allow affidavits to be filed without compliance with formal requirements like the signing and the properly making sure that it's properly witnessed, so long as the lawyers undertook to file before the hearing date an original of the documentation that complies with the formal requirements.
Okay, thank you. Our next question is back to Chief Justice Joyal. Although jury trials are currently expected to resume in the Court of the Queen's Bench in September of 2020, what do you anticipate will be the biggest challenges to ensure that those jury trials can proceed? And what, if anything, are you expecting to do to address those challenges?
Well, there's a couple of challenges, and I think the challenges relate to assuming there isn't another spike in the next number of months, a spike that would manifest in Manitoba. At the very least, what we're probably going to be living with, assuming without knowing, of course, that there isn't a solution to this problem. And we're going to be living with a situation where we're going to be in a situation where we're effectively coexisting or living with a dormant virus at best. So there's going to be fear on the part of jurors, potential prospective jurors, about participating. There's obviously a real responsibility on the part of the court to ensure that that fear is addressed. So that plays out from the beginning of jury selection right to the actual trials themselves. So let's start with jury selection. The way we select juries in Manitoba is we bring forward a very large pool, particularly when we're picking more than one jury at any given time. A very large pool of people who, needless to say, would be a case study in how not to congregate in a pandemic. So we have to find a way for that front end challenge, jury selection, to be done and performed in a way that respects physical, social distancing, call it what you wish, and ensure as well that those individuals who are summoned for jury duty aren't so psychologically unsettled that they may not show up or choose to simply co-opt once there. So that's a problem, and that's a challenge I think we're going to address probably by going off site and maybe at a local convention center, do one or two of those in separate clusters and ensure that the numbers are reduced and that the active jury selection is performed in a way more consistent with public safety protocols. The second problem in relation to jury selection is the psychology, and I touched upon this a moment ago. There's going to be a very real reluctance, I think, on the part of the citizenry to want to participate in jury trials, in jury interaction, knowing, as they will know, even if perhaps their perception is going to be a little bit inaccurate because they're going to have to take special precautions, knowing as they do that they're going to be, in some ways, in enclosed settings with at least 11 other people. So we're going to have to psychologically address that, and we're also going to have to do that at the front end, because I suspect when we're conducting jury trial selection, we're going to be hearing new and novel concerns about why it is they don't want to participate. So that's selection. That will be done off-site. The actual trial process itself will be similarly, I think, challenging. I think the accompanying precautions and the accompanying measures taken by the trial judge will obviously be critical. So we're going to have the usual social distancing that will have to start on May 25th in our court, because I said we're up and running with in-person trials as of May 25th. So the choreography, as I'll call it, as it relates to courtroom interaction, is going to have to be overseen by the judge, so as to ensure the physical social distancing requirements are met. The courtrooms will be sanitized regularly, and plexiglass where necessary between witnesses and judges are put in place. As it relates to the jury rooms and the congregating of the jury at breaks, or ultimately for deliberations, we're going to have to probably use a second courtroom, or if we're off-site, we're going to have a second room. So all of the physical spaces that are otherwise benign sort of realities in a normal jury trial now become important focuses of challenge. And we have to find ways to not only mechanically get through the process, but as importantly, as I said a moment ago, provide a level of psychological comfort, not just for counsel, obviously, and accused, witnesses, but also for those 12 citizens who are probably going to be more nervous than they otherwise would have been in any event. Let's be honest, jury trials for citizens who are serving on juries do constitute, in some ways, a nervous experience, even if at the end they're usually enriched by it. So that's what we're concerned about. We're very confident that we can make this work. We have a plan A, B, and C in place. What we don't know is whether or not we're going to be facing a spike that may preempt those trials.
Okay, thank you very much. That's very comprehensive. So many of the changes that have been implemented have really been recorded in the notices to the profession. However, of the changes that were implemented in judges' daily procedures, how much have you witnessed it being an exercise of discretion as opposed to the changes that are strictly put in writing to the notices to the profession? And are there any examples that either any of the panelists can think of?
I'll jump in on that. Yeah, I think it's clear that the courts have the authority over their own court proceedings. And I think within that, there's quite a bit of discretion as to how matters can be managed. I think all three levels of court quickly got together to decide how we would approach a lot of these issues. And we struck a task force with an executive from court administration, and we've spoken to stakeholders to get input from them across the board on many, many issues. And a lot of that is reflected in the notices that we've put out to the profession. I don't think everything has been, or potentially it could be, but a lot of the decisions are very practical, such as, are we installing plexiglass into courtrooms, or how are we managing some of the sanitization? Those are things that just, they're decisions that we're making that are not going to go out in a notice to the profession as things that we're doing based on the health evidence that we're being given and how we should proceed. I think there are some challenges. We've found some challenges in the provincial courts specifically where we may need some help legislatively. And that would include things such as the electronic filing of documents. And do we have the authorities to do that in all the cases that we need it? Another example would be telewarrants, for example, because the provincial court issues a lot of warrants, and how and when you can use telewarrants, which would be done remotely as opposed to the police showing up in person. Those are issues going forward that we may have to look for some legislative changes, some assistance to be able to do some of those things.
One point in terms of your original question with respect to the exercise of inherent jurisdiction or otherwise, it may be an obvious point to Chief Justices, but maybe not so obvious to the profession. But the Supreme Court of Canada is pronounced no less on what is the exclusive jurisdiction to the chiefs of scheduling. And really, when we're talking about what has been uniquely done by all three chiefs in this instance, we're really talking about, to the various degrees, our approaches to scheduling. We may have subtle or in some cases distinct differences, but what we all, in most instances, are talking about are scheduling. Yes, we're talking about technology and all the rest, but those are the refinements and details of what we're doing. The essence of what it is that we're grappling with is, how do we schedule? How do we respond? And how do we sort of react to the responses? All of that is scheduling, and that is, without question, in the exclusive and important jurisdiction of Chief Justices.
Mr. Cisyk, if I can just jump in, unlike the Court of Queen's Bench, the Provincial Court and the Court of Appeal, we don't have really inherent jurisdictions. We derive our jurisdiction from statute because we're not the Court of the Queen. But of course, as Chief Judge Wiebe indicated, there is one principal exception, and that is that we always maintain the control over our process to ensure that we're not prevented from being able to carry out our functions. And when the pandemic hit, we were not able to carry out our functions. We were facing the unknown. The danger was real. We heard about the deaths that were occurring in different countries, so we had to move very quickly and essentially shut everything down until we were able to assess the danger and start measuring risks. But during that time, I can say that we quickly realized that what we're going to have to do in the future was to move to video conferencing. Well, we didn't have any rules or regulations that allowed us to do that. In September of this year, there was a new Part 12 of the Criminal Code that brought in amendments to allow for video conferencing. So what we did was we asked at the beginning of April for the government to amend our rules by allowing us to hold remote hearings. And I think this has to be a record. And this shows that in emergency situations, government will and can react very quickly. Well, Mr. Sisek, inside of 15 days after our request, we received the amendments to our Court of Appeal Act to allow us to proceed to hear hearings remotely by video conferencing and teleconferencing. And so that's how we were able to deal with it. We've also got certain authority in our rules that allow the Chief Justice to call for case management hearings to deal with different situations, and we have been able to deal with that. But at the end of the day, to answer your question, all three courts, I think from what you've heard, were able to pivot quite easily and quite comfortably during this crisis situation.
Okay, and that brings me to the next topic here, which addresses the flexibility that's been employed. So since the beginning of the COVID-19 situation, the Court of the Queen's Bench has addressed their cancellations and limitation of service with a staged approach by using administrative and assignment lists, as well as segmented decisions about scheduled matters respecting discrete periods. For example, the periods that were mentioned earlier, March 16th to April 17th, April 20th to May 25th, and May 26th to June 30th. It chose this approach rather than adjourning some or all matters sine die, as was mentioned earlier. Justice Shaw, why was this choice made, and how has it assisted your court in terms of avoiding specifically backlog and delay?
Well, as I suggested earlier on, Mr. Sisek, it's given us a very clear control and I think a fairly intimate knowledge about each of the files. I'm staying up at night learning about each of the files, but broadly speaking, the types of files that are adjourned in the criminal, civil, family, and child protection areas. They have not been adjourned, as I say, into a vague and distant future. We know that they're going over no more than 4 or 5 weeks to one of these lists, at which time they are then rescheduled either to the earliest date possible, which in most cases is within acceptable parameters, whether it's in a criminal realm respecting Jordan or some of the other parameters we've set up, or on that same list, counsel in certain areas are given other options. So for example, in the case of civil proceedings, for those cases that were adjourned, cases that were set for trial, they've been put to an assignment list, at which time, pursuant to a notice that issue, counsel have an opportunity, if the case is under 2 weeks, to reschedule the matter for the summer weeks, where we're involved in a blitz more intense than ever in terms of judicial resources. Or alternatively, they could set up a mediation, or alternatively, if they choose to reject both those, they set a new trial date for a further date into the future. Now, the date is further off in the future, but they're also, in that context, facing, I think, 2 very interesting and I think agreeable choices. My point is, in each of the areas of our service, some type of option like that exists, but the point is, by the time we get to the end of June, in this case, actually the end of May, because June, it's business as usual in terms of scheduling, not in terms of the type of service or adjudication that's taking place. By the end of May, all cases will have been rescheduled within a time span or a period that we can account for and that we know is not otherwise intolerable or violative of either a constitutional principle or our own scheduling parameters. So that's worked for us in this instance very well, and we're quite pleased with those lists.
Okay. Thank you. This is another question for Justice Chartier. The April 3rd, 2020 notice to the profession states that appeals will be heard by video conferencing and motions or applications would be heard by teleconferencing. Is there a reason for the distinction between the two, namely video conferencing and teleconferencing? And is the restriction of motions and applications to teleconferencing a matter of a limitation of court resources or a matter of accessibility?
Right. I remember when we issued this notice at the Manitoba Court of Appeal beginning of April, we did get a few requests as to why the distinction between having video conferencing for appeals, but not having video conferencing for motions or applications. And the reason for that is quite simple. There's nothing nefarious about it. Many of those that are appearing in Chambers Court are self-represented, and therefore we, after discussion with the registrar, we decided to elect to proceed with the most accessible form of technology, and that was to go by teleconference. It's not a matter of limitation of court resources. It was just a matter of ensuring the best form of access to justice during the pandemic.
This question goes out to all of the panelists. Many parties require interpreters in their hearings. What has been your experience in facilitating interpreters' participation in the court for either remote hearings or in-person hearings? And I'll put this question to Chief Judge Wiebe to begin.
Thank you. So since COVID, we have not had a huge need for interpreters. We do use them regularly in the ordinary course. We have, though, pre-COVID, had interpreters attend by video, and that's particularly so when there is a language or a dialect that we don't have access to readily here. And so we have had people appear from Toronto, for example, on a video screen into the courtroom, and we have dealt with the matter that way. So I don't expect it'll be a big issue going forward. It's already been tried and done.
Okay. And your experience, Justice Royale?
Really, we haven't had any COVID situations with respect to interpretation. The only problem with interpretation we've had is perhaps in the understanding and interpreting some of my practice directions.
Okay, thank you for that.
I can say, Mr. Cisyk, that at the Court of Appeal, we've only had one appeal where interpretation was asked, but it was asked not in time. Notice hadn't been given, proper notice had not been given to the Crown. So as we do in Manitoba in most situations, we tried to deal with it as best we can. So we simply, when the video conference went for a break, we arranged for another video conference invitation to be sent out to counsel and the accused so that they were able to speak with only both of them on the line. And then after the break, we'd come back without the accused being able to hear but not being able to participate. So we were able to get on the phone line to make sure that giving the accused access to his lawyer and to see if he understood everything that had occurred. And in that case, there had been a few situations where the accused was not able to follow what had occurred, and his counsel simply interpreted or gave him the information that he required. He was able to understand some English, but it wasn't his first language. And so we simply, you accommodate and you transition into a way that we can best ensure that the hearing is a fair hearing for all parties.
Okay, thank you. This is a question again for each of the panelists. Can you share your experience working with administrative staff remotely, as well as your internal research services with as well as completing internal research service? I know the answer earlier was that a lot of staff are still operating in close conjunction, but has anything changed, or what have been your experiences with that?
I'll simply say, and I think my colleagues will affirm this. The three of us, we don't have much experience because we're here almost 7 days a week, for long hours. So we haven't had that experience. I know our colleagues in my court, for example, are dealing with a situation where at least half of our judicial assistants, in kind of an alternating way, are working at home. That's for the purposes of ensuring that we're able to social distance in an adequate way, and that comes back to the initial goals of leveling the curve and ensuring that we're not doing anything that would aggravate, obviously, our desire not to transmit virus. So that's worked very well. On the practical level, that arrangement with our assistants working at home apparently is serving our court very well indeed. So, so far so good. There's been no problems with the administration. I think my colleagues will probably share my view as well, that in terms of the administrative staff with whom we deal at a fairly high level, they're here all the time, always accessible. So we're not really in a position where we're having to sort of search people out who are in some way hiding in a remote part of the city. They're all very engaged. But where there is that kind of pragmatic and necessary safety measure taken, from what I can see, it's worked out quite well, practically speaking. It hasn't led to some of the glitches we might have sought. That's my experience.
I can say, Mr. Sisak, that in terms of numbers, again, I always look at what the stats are. We've got judicial staff and we've got courts administration staff. And Chief Justice Royal has talked about judicial staff, and most of them are there. There are some assistants where half of them go home, half of them stay at the office. With respect to court staff, and that includes the sheriffs, there's 700 court staff that works here in Manitoba. About 24 or 25 worked from home, but the rest of the 700 staff were at the office working. So it's a different situation, a different reality than in Ontario, for example.
Mm-hmm. Chief Judge Wiebe, is this?
Yeah, I would agree with that. I would just say at the beginning, of course, it took us a little while to figure out how we were going to manage all of it. We had some technological challenges for those people who were at home where the system was overwhelmed, and anyone who was participating in any sort of teleconferences would have, phoned in at some point only to have the lines all be busy. We had to figure out, the social distancing things at the beginning without any of the personal protective equipment, because that wasn't available at the outset. And so there was a lot of sort of dancing around and trying to figure out how to properly social distance. But overall, I think it's worked out pretty well.
Okay. So for our next question, costs are regularly used to deter counsel from unprofessional practice, sharp practice, or from causing delays. In assessing scales of cost award for various proceedings, have you adjusted the severity of costs awarded in order to further dissuade counsel from taking advantage of the current situation? And as a follow-up question, during this time, is there any type of conduct you have encountered by lawyers in your courts that you would like to discourage, or conduct that you anticipate that you would like to discourage in advance? And this is a question for all of our panelists. I'll start with Chief Judge Wiebe.
We don't typically award costs, so I won't address that portion of it. But with respect to conduct, I think, again, I'm going to say it took us a little while to figure out how to manage through teleconferences, more so than video. We have used video regularly in our courts, so that was not so new. But I think it's more of the practical implications of being on teleconference, who calls in when, and muting your phone when you're not speaking is probably one of the biggest things that has to be done. I think the U.S. Supreme Court recently figured that out. But I think it's more of that behavior, and not interrupting when somebody else is making submissions during a telephone conference, and being silent until there is a moment that you can speak, certainly making your presence known at the earliest opportunity without interrupting anybody else. So I think we're going to find that we're developing a whole new social etiquette and courtroom etiquette that is going to have to come through teleconference.
Mm-hmm, definitely. Chief Justice Royal?
Let me deal first with the issue of cost. We haven't experienced a situation where we've had to impose in any sort of unique or unusually denunciatory way costs. In fact, I want to underscore hopefully what I said earlier on. We've noticed a singularly collaborative spirit with almost everyone in the bar in terms of trying to inform to our new and quite extraordinary processes that we've set up. And we certainly didn't want in any way, and hopefully we made this clear early on if there was any concern, that we didn't want what might be, in some instances, retrospectively, questionable applications, say in the area of what's urgent, what's emergent, is being mired with the uncertainty of costs. The difficulties I think counsel faced early on trying to navigate emergency or urgent motions using COVID as a factor, I think mitigated or militated against us clubbing anybody with costs that probably in the circumstances would have been incongruous. In relation to practices that we might want to discourage, I would echo Chief Judge Weed. The only thing I'd say, and I was being facetious a moment ago about the interpretation of our notices, or my notices, and our practice directions, I find it sometimes frustrating that council don't maybe continue to consult the notice and the practice direction, because while they're not pieces of literature or perfection, most of the questions that are burdened or burden our trial coordinator are answered in that practice direction. And if there's nuances and refinement, I understand that some of the questions, I think, are addressed and answered pretty clearly in those notices. And it hasn't always been helpful for our trial coordination section, who are just incredibly busy and incredibly set upon right now, to have to use their time answering those questions. But again, I'm reluctant to sort of bring that piece of negativity to the discussion, because almost across the board, council have been superb in their attempts to inform to this quite obviously a unique set of processes that we set up.
That's great to hear. Chief Justice Chartier, did you have something to add there?
Very briefly, no one's tried to take advantage of the situation that I've seen, so we haven't had to deal with the issue of costs. With respect to conduct that we would like to discourage, and this is, it's not a criticism, but I've been case managing all matters dealing with having to deal with new processes because of COVID, and the first matter that I had to deal with was an adjournment request by senior counsel, very respected counsel, who was a certain age, who had an underlying condition, who was under doctor's orders to stay home, who had no internet at home, and who was asking for an adjournment. And I had to say no to the adjournment, in the sense that he was indicating that he wasn't able to access the new technologies. And unfortunately for him, I said, no, that's doesn't cut it. There are new technologies, and they're not really new technologies. They have been in place. They're fairly simple, and I indicated to that counsel that he's going to have to get someone, from his firm or some grandchildren to come and help him out to use, hotspots from his cell phone. And maybe use an iPad for the video conference. He did participate in the video conference, and I can tell you, having seen the whole video conference, he was very much at ease at the when it ended. It was like a fish in water. So it all's well that ends well.
Okay. One question here, though. You mentioned Justice Chartier mentioned case management. Has there been a push in the courts for more case management during and in the wake of the pandemic? And do you think there are resources for more case management, or that there should be? I'm not familiar with to what extent Manitoba had previously engaged in case management across its cases, but has there been an increase?
Well, all that sort of weighted initially. It's such a difficult question, because every court has their own definition of what case management means, the unique body of work they do. In our court, for example, which does offer services in the area of criminal, civil, family, child protection, every one of those areas has a form of case management which is acquired and is designated in a unique way, and which involves a unique sort of judicial supervision, in which unique activities and unique judicial functions can be served. So it's going to be a difficult topic to address. I'll simply say that we've tried, because of the general utility of case management, or in our civil realm, pre-trials, because of the importance of what those fora do, we've tried to get those up and running as soon as possible. In the civil realm, for example, with the extraordinary collaboration of the civil bar, we were able to get something up and running relatively soon at their instigation and with their help, so as to allow us to effectively infuse into what it is they do a level of normalcy. So case management, insofar as it is offered in every one of those areas, is now up and running in a fairly normal way, but it's all done, again, remotely, either by video conference or teleconference.
I can add that we routinely use case management for our trials, and we've continued to do that through the pandemic. We have done more case managements over the last period of time to try and triage some of the matters that are coming up. We cannot do case managements for all of the trials that are scheduled. We have thousands of matters that go through our courts, and we simply do not have the resources to case manage each one of those. Some of our other court centers are able to manage better than we are here in Winnipeg. But it's a very useful tool to narrow the issues and to see what can be resolved. We'd like to be able to do more of it, but it's very difficult in the circumstances.
Okay, thank you. So this will be our final question here. We only have about 2 minutes left, but I'd just like to hear briefly from the panelists what changes that have been implemented so far you'd like to see going forward when we return to some normalcy with respect to the pandemic. I understand that Manitoba has had the ability to very quickly and efficiently return and have a plan for return, but what would you like to see positive coming out of this going forward?
I can maybe start on that very quickly. You know, we do have we now have the video conferencing tool in our toolkit. I want to make it clear that we're not going to continue once COVID is done. We're not going to continue with video conferencing. We're going to go back in person, but we will have the capacity for exceptional matters to hear matters by way of video conference now. I think all of the judges of our court are now comfortable with it. We've changed certain things in terms of the way we deliver our decisions. Before, you'd receive a call from our office saying the judgment is ready for pickup. You can come and pick it up at our office. We're now using new technologies to deliver our decision. It's called email. Yes, if you can believe it, we're going to be using email, this technology that was there for a long time. Rather than having counsel go down, we're using that. We've also moved towards e-signatures, where we had signatures, of course, what we call the wet signature, because the ink requires it to dry, but now we've moved towards e-signatures, which is simply an image of the wet signature. And as long as written permission is obtained from judges for each occasion that they digitally sign an order or a judgment, that's all that is required. So those are things that we're going to continue on.
I can tell you that when all of this is over, talking like someone who's in the midst of a war, when this experience is over, we're going to do a serious institutional self-examination in terms of our court. But I can tell you there's a lot of things that we're going to probably take to the profession, myself, and Associate Chief Justice Perlmutter, to canvass in terms of what ought to be retained and what ought perhaps to be refined and retained in a different way. But let's, for example, just take the issue of video conferencing or teleconferencing in the area of civil proceedings. Right now, we're doing that in a way so as to permit pre-trials, case management meetings, and the like to occur in a way that actually permits contested motions to be done without a record. And let's go back to a basic reference point. We all have our own definitions of what maximizes or facilitates access to justice, but I like to invoke myself the Cromwellian reference points. Those are those of former Justice Tom Cromwell of the Supreme Court of Canada. To the extent that we can encourage processes that are less costly, less complex, and quicker, we ought to be doing that. And to the extent that we've done that in the various areas of our service, we would be remiss if we didn't ask ourselves, is this something we can or cannot retain? So in the area of civil proceedings, for example, we're doing motions now by teleconference or video conference without a formal record, with an agreement from counsel to begin with, but with the assurance that everybody is identifying what it is that's before the court, what it is that they expect the decision upon which the judge is going to be making adjudication be based upon. And as long as there is, in fact, sufficient submissions from counsel and sufficient reasons from the court, I think that will withstand a review by a higher court. Those are things that we want to look at, and those are things that I think facilitate not only efficiency, but access to justice using the definition I just offered up.
Thank you. And Chief Judge Wiebe, any final remarks on this point?
Yeah, I'll just say very quickly that we will also be doing an assessment of what works and what doesn't work. We have for a long time recognized that we need additional access to justice in the North, for example, and teleconference and video are critical to that. I think this has hastened and highlighted how those can be used in a beneficial way, but not all matters lend themselves to teleconference and video, and particularly with the scope of work that we deal with, there are a lot of vulnerable people, and you need those people in front of you so that you can be sure that they are actually understanding the proceedings. So we'll take a good hard look as well, and I think there's going to be some great takeaways from all of this, and we'll move on those things that work. Okay,
thank you. Well, that concludes our time for the webinar today. Justice Chartier, Justice Shoyal, Judge Wiebe, this has been incredibly informative. I'd like to thank each of you very much for joining us and sharing this information. Thank you as well to all the attendees for viewing. A recording of the webinar will be posted on the LexisNexis Canada website as well. With that, stay safe, everyone, and have a great weekend. Goodbye.
Thank you very much. Bye-bye.
Merci beaucoup. Au revoir.